Thank you. All right. I will summarize the bench conference of this moment. At this juncture of this case, the case number is 215 SGPI 239. There is no indictment been returned by the grand jury. Therefore, there are no charges pending before this court that I can disqualify Mr. Wright and his staff from prosecuting because there's no charging document. There's no charging document, therefore Ms. Rosenbaum has not entered a not guilty plea to a charging document, which I assume to be complete. Therefore, I'm confining the motion for the day's hearing to disqualification of Mr. Wright and his staff during the investigative phase of the case, which is ongoing, and presentation of the case to the grand jury. The point being, if the grand jury does not indict, then there's no further activity in the case to be had to disqualify anybody. It's somewhat premature. Ms. Ball, I have thrown out of defense for her. She makes sure she didn't miss a deadline of filing. We don't know if there's a deadline. This is a little bit of a unique situation. So, to that extent, I have no need for me to hear witnesses that are being proffered that would testify at a trial when we have no charging document at which that trial could be called. Try that. So, Essentially, what we're proceeding on is for a motion to disqualify district attorney and staff from the investigative phase of the presentation of the results of that investigation to the grand jury seeking to charge her client with, I will assume, the underlying charge of murder. It's not listed on my calendar, but I assume that's what it is. All right, now, in that regard, Ms. Moll, if you wish to present them, you've presented to the court a list of witnesses you intend would have called. I will not preclude you from calling those witnesses at a later date should a charging document come forward.
I understand. I would just...
And their rights would be preserved to, again, move to disqualification of Mr. Wright and staff. Ms. Moll has pointed out that Mr. Wright, as of January 2017, barring some very unusual circumstances, Mr. Wright has not sought re-election. Therefore, in January of 2017, we will have a new district attorney. None of the current members of the staff of the district attorney's office. So there's only one former staff member running. And so,
I understand, Your Honor. I just would object to not being able to present the witnesses to preserve the record. I understand.
What they would testify.
I will be happy to proffer. I just want my objection noted for the record.
And if you'll come to the podium, I'm ready to pursue it.
Thank you, Your Honor.
Your Honor, what we are seeking is to have a fair trial and have a fair investigation of the case, have a fair presentation of the case to the grand jury. And we feel that this district attorney's office is tainted by Mr. Wright's former relationship and the witnesses in the district attorney's office, their relationship with Jennifer Rosenbaum. We had the first witness, Your Honor. I'll sum up after I proffer for you what they would say. The first witness would have been Mary Evans Battle, Your Honor. And Miss Battle, we would anticipate, would testify that she had been present at two different argument situations between Mr. Wright and Ms. Rosenbaum. That she had witnessed them, she had witnessed the atmosphere surrounding them, and was present and discussed it with Jennifer Rosenbaum. She similarly was present when third phone call came down from the district attorney's office, and asking whether or not Ms. Rosenbaum was actually still going to be working there, what the situation was. We contend that the evidence would show that he did not want her to work there any further because of violations he felt she had committed against the office by talking to commissioners and talking at commissioners. This Battle, Your Honor, would also be testifying as to, she'd be a witness in the defense's case, as to children, the period of time in which the children were here in McDonough and have been seen, and certainly the Mary Evans Battle had an opportunity to assess for herself whether the child looked abused, the children looked abused, whether they looked malnourished, whether they were covered in bruises during the period of time. The period of time that has been alleged in the warrants is June 13th through November of this last year that this was passed. And during that time, she was exposed numerous times, and at least up until August, if not further, and had been exposed to the child in question, and had gone to lunch with Ms. Rosenbaum with these children, had gone to the movies with these children, and had seen the state that these children are in. Your Honor, I also mentioned that that is what we intend to elicit from several other witnesses when we speak of the condition of the child. the witnesses would testify that Ms. Jennifer Rosenbaum brought the children to the VA's office on numerous occasions while she was working there, and that several people on our list are Mary Evans Battle, Lynn Dial, Patricia Wade, Kaya Simmons, Ashley Bednart, and Avani Patel would all have had opportunities, same as Ms. Battles, to see whether these children had been abused in any way or sporting any type of bruises or had been in any way appeared malnourished, whether they had had the necessity to get food to these children. So that's what those witnesses would testify to. With regards to Linda and Patricia Wade, they are employees of the district attorney's office, and they would testify as to a phone call that came down from the district attorney to Ms. Wade, indicating that he did not wish for Ms. Rosenbaum to work any further in his office. What we are seeking to prove, Your Honor, is that there was a contentious relationship between Mr. Wright and Ms. Rosenbaum, such that he is not a proper person to prosecute this case. The state of Georgia is big and wide, and there is no reason that it has to be Jim Wright or his successor, given that we have witnesses in the DA's office. The witnesses in the DA's office are substantive witnesses to the meat of the case, to the investigation of the case. When we have other witnesses that we intend to call, Your Honor, are Mr. Marshall, Detective Marshall. Detective Marshall, Your Honor, is a detective who handled the complaint by Ms. Rosenbaum of harassment at the hands and letters and writings of the Justice Malayla group. And we would anticipate him testifying as to the efforts he made to investigate the case, and who he spoke to, then he spoke to the DA's office, and the result of his investigation of this case. With regards to Kip Moss, our point in calling him would be to elicit the evidence that he was related to Bo Moss, who was running against Ms. Rosenbaum at the time that these charges had been levied against her.
We were aware there was an election. Was there an election already pending?
Yes.
It was Rosenbaum qualified for election. You say he was filing fee?
Yes, it was so.
When was that?
It was when she was about half of the that was in
2015?
no, 2015, yes.
Great. I filed my declaration of intent.
It's a declaration of intent.
Oh, declaration of intent, that's to collect money. You have to file a declaration of intent to ask people for money to run. If you don't qualify.
Exactly. But certainly she was not in a position of, shall we say, not on the same side as the Mosses. And when the arrest warrant came down, we note for the court that this was an arrest warrant without an autopsy, without cause or manner of death. And that goes further to show the animosity, certainly the potential for bias against Ms. Rosenbaum. Avani Patel is a person who worked in the district attorney's office, similar to Ms. Rosenbaum. But Ms. Patel, unlike Ms. Rosenbaum, was never called into the office by Mr. Wright, who told her to exercise her First Amendment rights to talk to people at commission meetings or to speak at commission meetings. unlike Ms. Rosenbaum. I keep hesitating because I figured her maiden name was Holcomb, and we've got listed as Jennifer Holcomb Rosenbaum. But with regards to Avani Patel, she is also a person who saw the children and would be able to testify as to the condition the children were in at the time that she too was an intern with Ms. Rosenbaum. Tanya Simmons Denham is in that same position, as is position of testifying about children, as is Tanya Simmons, Mary Evans Battle, and Patricia Wade. These are all people who have been with children, have sent their own children to this, into Ms. Holcomb's care, into Ms. Rosenbaum's care. So we are contending, Your Honor, that as a result of all of these conflicts, I left one person out because I don't believe that she would be necessary, she's only necessary as an impeachment witness in the event there's any contention that Mr. Moss is not related to Bo Moss. And I know the court mentioned that it was just a declaration of intent, but it was a declaration of intent against Mr. Moss's seat, and certainly that put her in an adversarial position. Additionally, we would have brought up evidence that Mr. Kip Moss, Mr. Bo Moss, and Mr. Wright were all very tightly together. They were friends. They campaigned together. In fact, we have attached a picture showing that. So there is a political thread that runs through this case, and it's noteworthy that the arrest came down, as I said, during the time period where Mr. Moss was made aware that he was going to have opposition. Your Honor, in conclusion, we want a fair trial, we want a fair investigation, we want a fair grand jury presentation. And that cannot be done unless the DA and his staff are excluded. If you have, as the court mentioned, a new DA, that only cures it somewhat, because we still have the same, possibly have the same staff, and they still have allegiances to the office and still have allegiances to the person in power, whoever that might be. It is a situation where we are talking about a citizen versus all of law enforcement. Law enforcement, the McDonough Police, the Henry County Police, and the District Attorney's Office. So the conflicts that these people have and we perpetuate, even were there to was the right not to be the prosecuting attorney, or this case not to arise at the time that he was the attorney, district attorney. And I also would like to mention, Your Honor, we know it's not going to be, we just don't know what's going to happen. We know he's not going to be able, we don't know what's going to happen in the court's calendar, whether things are going to fall through, whether it might actually occur within the time frame that Mr. Wright is in the office, in which case, again, we come to you saying we don't think we should be investigating the case, we don't think we should be presenting the evidence to the grand jury. And that goes for him and Dick Moss both. If I may have just one moment and I'll be finished.
Wow, I think you have it all.
Your Honor, in conclusion, I just want to preserve my objection. I wish we could have done this with the witnesses, which were all subpoenaed, correctly subpoenaed and brought here today, and we could have done it so we could have heard directly from them. Unfortunately, as I said, you ruled otherwise, and we abide by the court's ruling that we do know our objection to the record. Thank you.
For purposes of your motion, I'm going to assume that each of the witnesses will say what you have proffered before they will say. Just the same as a motion to recuse is filed against the judge. You have to assume that all the facts are true. And that if they're all true and it's time to be filed, I got to step aside or another judge here. So I'm assuming for purposes of the motion that everything you told me, these witnesses will testify to is true. So I don't have to hear from them because that's not the credibility whether I believe what they say or not. I'm going to assume it's true. Okay?
And yeah, I understand that.
Okay.
And I appreciate that.
Thank you.
Yes, sir.
Thank you, Your Honor. And it is my understanding that this is limited as to presentation, the disqualification of the district attorney's office as far as going towards the presentation of the grand jury process. Is that correct, Your Honor?
Yes.
Okay. Just for court's information, I'm sure the court knows, the grand jury process, how that happens here in Henry County and I'm assuming in other counties, is that when the police begin an investigation, they collect evidence, they interview witnesses, they generate reports. And at some point, those reports and that evidence comes over to the district attorney's office and it is assigned to one of our investigators. And at that point, our investigator looks at the case, the evidence, the reports, and they create a billed indictment, which has the charges on there for presentation to the grand jury. The court is well aware that the district attorney's office does very little, if any, investigation itself. That is left to the police department. We just simply take that information, gather it together, look and see what the charges ought to be on the charging document, and then prepare that and take it and present it to a grand jury. The grand jury process is a process that was created as a check and balance between a defendant and the state to allow between 16 and 23 citizens, average citizens of the county, to hear the evidence against a potential defendant and decide whether or not to then send it here into Superior Court for further prosecution. And to that end, the grand jury, Your Honor, consists of only testimony from witnesses of the law enforcement, victims, detectives, police officers, things of that nature. In the grand jury room, there is no defendant, there is no defense attorney, there's no one on behalf of the defendant, the possible suspect or defendant, to advocate for them. That is how the grand jury process was created. Therefore, I'm at a loss to understand how, when we receive the evidence that the Henry County Police Department has collected as far as the death of Layla Daniels, how, once we create and generate a document for presentation to the grand jury, and in this case, at this point, knowing the information and evidence that I know of and have heard from detectives, that is going to include a count of murder and possibly a count of felony murder, possibly a count of aggravated assault, possibly cruelty to children. I'm just speculating at this point, but that's what I anticipate is going to happen. I'm not sure how that process I have just described could be interfered with by Mr. Wright because of alleged contrition between himself and Ms. Rosenbaum. But just for the record, I want to put that on here to let the court know that that's how this grand jury process works. As far as the proffer by Ms. Mull regarding Mary Battles, what she anticipated her testimony would be, she gave no specifics about any kind of contentious or argumentative discussion between Mr. Wright and Ms. Rosenbaum on these, what originally I thought in this motion was 2 occasions, but now Ms. Mull has said 3 different occasions, one of them being apparently a phone call. As to Lynn Dial, Patricia Wade, Ashley Bednarz, Tanya Simmons, and Mary Battle, they all work in our juvenile court office. Mary Battle is a senior attorney down there, and she runs that office. That office is a satellite office to the district attorney's office. They are off our campus. We do not have normal, regular contact with them. And that is where Ms. Rosenbaum was not employed by the district attorney's office. She did not work for the district attorney's office. She was doing a 3rd-year practice as an internship here that is allowed by Mr. Wright to occur. We have 2 3rd-year practice attorneys in our office right now. We allow those people to gain experience through this office, Your Honor. It's not a right, it's not a privilege, and it is not an employment. Those persons would be called, I'm assuming, through Ms. Mull's testimony or her statement to the court, to give evidence as far as their observation of Ms. Rosenbaum and Layla Daniels and Millie Place, the 2 children, and their relationship and their observation of the children's health. That is not something that would be presented at grand jury, Your Honor. That is something that would be, if it's presented, it would be presented at trial. So that is not relevant in this matter. As to Detective Gerald Marshall, Detective Marshall was not involved in the actual death investigation of Layla Daniel. He was superfluously involved in allegations that were made by Ms. Rosenbaum regarding persons that had followed her when she was in public, had made statements on social media that are outside the control of the district attorney's office, and had made alleged threats to the Rosenbaums. Detective Marshall investigated those allegations, and in my speaking to him, and I would proffer that he would testify that he presented facts to the magistrate court in a hypothetical situation that were based on what the Rosenbaums had claimed, and at that point the magistrate judge informed him that because the threats were conditional and were not immediate, that he would have declined to issue warrants in that case. And that is what I proffered Detective Gerald Marshall to testify. There is an allegation in this motion that alleges that Detective Marshall told, I don't know if it was Mr. or Mrs. Rosenbaum or both, that he works for the district attorney's office, and what they tell him to do, that's what he does. I would proffer that Detective Marshall would testify that he did not say that he would contact the district attorney's office on occasion, but he has the ability to investigate, and he operates under the authority of the chief of the Henry County Police Department, not under the authority of the district attorney's office. As to Kip Moss is the chief investigator in the Henry County District Attorney's Office. He has been for some time. Because he is the chief investigator, it is his job to supervise the other investigators. It is very rare that he becomes involved in actually drawing up cases for grand jury and doing investigations. He is mostly in a supervisory capacity. And to my knowledge, And in fact, not to my knowledge, but I know that Kip Moss has not been involved in the investigation in this case or the preparation of the indictment, because this case has been assigned to another investigator in our office. I would proffer that Kip Moss, if he testified, that he would testify that he and Bo Moss, the county commissioner, are in fact related. However, that at no time did he and Bo Moss and Jim Wright collude in order to first campaign together. And I would, the court has the motion before, there was a photograph that was included in this motion. And you see in the photograph the young lady, she's in her 20s, the young lady pictured there holding a Jim Wright and a Bo Moss sign. However, you'll also notice that Bo Moss is not present in that photograph, nor is Jim Wright. So it is a leap to assume that they are campaigning together, that they're good friends, and that they did this together. The young lady that's pictured in this photograph is Kip Moss's daughter. So Bo Moss is her cousin, and Jim Wright has known her all her life. And she just happened to be out there and holding signs. I'm assuming that the leap here by Ms. Mull is that Bo Moss, Jim Wright, and Kip Moss would collude to save a Henry County commission seat by putting someone under arrest and having them prosecuted for the murder of a child in order to save Bo Moss's county commission seat. That's the only leap I can make in this case. Your Honor, had we had this completed hearing, I would have placed Mr. Wright on the stand to testify, and I would like to proffer Mr. Wright's testimony in this case. Mr. Wright would testify that he had two specific conversations with Jennifer Rosenbaum while she was an intern doing a third-year practice here at the Henry County District Attorney's Office. That one of those first conversations took place on May 14th of 2015. That is when you, Your Honor, swore Ms. Rosenbaum in to her third-year practice. And that Mr. Wright, Ms. Battle, and Ms. Rosenbaum went into his office, and he cautioned her that this office maintains a policy regarding social media activity that is not. Mr. Wright is very particular about social media activity, and he wanted to make sure she understood that she needed to be careful about what she posted as far as cases, things happening in the district attorney's office. He would testify that it was not contentious, that it was actually a time where most everybody was happy because, especially the Rosenbaum, because she'd just been sworn into her third-year practice. Mr. Wright would then testify that several weeks later that he became aware that Ms. Rosenbaum had posted on some social media site a statement about a state representative that was critical. And he called her in along with Mary Battle at that time and told her that she needed not to be posting things of that nature on social media, and that at that time that discussion once again was not heated, or there were no arguments. It was a cordial conversation according to Mr. Wright. That's what he testified to. He would also testify that he knows Bo Moss, but he does not socialize with Bo Moss. He's acquaintances with him, and he has known him from his years of services in Henry County. The court needs to be aware and understand, and I know you are, that Mr. Wright came to Henry County in 1981 as a Henry County police officer. came to work in the district attorney's office as an investigator, and then went to law school and became assistant district attorney, and then he was elected as the district attorney. So he's been here since 1981, and he knows many, many people in this county, and many, many people in this county know him. That does not mean he is a good friend and socializes with people. He would testify that Mr. Wright would testify that he and Bo Moss did not campaign together, that what you see in this photograph was a coincidence with young Miss Moss out holding signs for both Bo Moss and Jim Wright. Mr. Wright would also testify, Your Honor, as far as the evidence that he received regarding the evidence in this case, that anytime there is a death of this nature in Henry County, Mr. Wright meets with detectives who are working the case, and he receives evidence from them, and oftentimes they actually come and seek out Mr. Wright to give him the evidence that they have at the time and ask for his advice as to how to proceed regarding what charges for warrants. And in this case, Mr. Wright would testify that Henry County detectives met with him, and they gave him verbal autopsy results at that time as to what they had received from the medical examiner. And at that point, the discussion was had on how to proceed and what charges. So, Your Honor, basically at this time, the evidence before the court is not sufficient. I apologize. Should I do my closing here, or are we out?
You'll get last word.
That's what I'm asking. Okay. Basically, Your Honor, the evidence before the statements and proffers before the court do not rise to the level of disqualifying the district attorney from doing his job that he has been elected by the people of Henry County to perform. He has no actual conflict, and he has no forensic conflict. The allegations of contentiousness between himself and Ms. Rosenbaum are, it's just not right. There wasn't a contentious relationship on Mr. Wright's behalf. And one of the ways to know that is because Ms. Rosenbaum completed her entire third-year practice internship. She was never made to leave. She completed the whole thing. And, you know, if there was a contention, he would have made her leave, and he didn't. They had a problem. Nothing that has no evidence or proffer that has been given to you today, Your Honor, rises to the level that would require the court to disqualify the Henry County District Attorney's Office from seeking an indictment in the case against Jennifer Rosenbaum and her husband in the death of Layla Dan. And based on the evidence and proffer that you have received today, I would ask you to deny this motion.
All right, Mr. Walton, you get last word.
Thank you, Your Honor.
I don't see what possibly could be coincidental about having Kip Moss's daughter campaigning for Mr. Moss and for Mr. Wright. That's not a coincidence. That's a planned event. It's not just one sign. There are many signs, multiple signs around her chair, stuck to the back of her chair and in her lap, as you've seen yourself, Your Honor, is attached to the motion. That's, introducing the documents would have been nice to have the witnesses to do that. Also, Your Honor, the other reason that it would have been preferable to have witnesses testify is that we can cross-examine, because you have now heard conflicting statements, and you've certainly told me that you take what I have represented as being the truth, but I assume you also take what the gentleman who is arguing against me is telling as the truth, and you have no opportunity to see Mr. Wright testify, have him cross-examined, see his demeanor, see whether you believe him or whether you believe the other witnesses. So again, Your Honor, I'm objecting to us not being able to have live witnesses. With regards to control of law enforcement, that what Mr. That's what the district attorney has said, what the state district attorney has said, is that he doesn't have control of law enforcement, and that's exactly the point we wanted to make by bringing in Detective Marshall, because Detective Marshall, while he mentioned nothing about doing a dry run with a magistrate judge, did in fact tell the Rosenbaums that he had to run this by the district attorney's office because he's their boss. And precisely because he said that, and it is not the policy of the district attorney to review simple assaults, which was what warrant was under contention, under consideration, that would definitely show, again, the link between the DA's office and the prosecution, the political link that shows appearance of impropriety. We are not required to show total impropriety or total conflict, but appearance of. And in this case, Your Honor, I would argue to the court that there is plenty of conflict. Without repeating myself, I also would note to the court that the gentleman from the DA's office mentioned that there had been a dry run to a magistrate judge. The question is, why wasn't a full run to a magistrate judge done? And this properly handled as any other case would have been had it not been Jennifer Rosenbaum. This was a simple assault case that they were seeking a warrant for, and Detective Marshall, we believe under cross-examination, certainly you would have had the opportunity to see whether or not you believed him with regards to what the district attorney now says he would say and what we have proffered to the court he would say. Going to the DA's office on a simple assault is not what happens here in Hamilton County or in any kind of county. So the fact that Mr. Marshall decided to come to the DA's office to talk about this case is exactly the point we're trying to make. It's not done normally, and again shows the predisposition of both the DA and the police department against Ms. Rosenbaum. We also would have anticipated.
To make sure I understand you, the fact that the detective in an unrelated factual situation to the underlying accusation here makes the election to go see the DA, that causes a problem for the DA. But the DA, what's he going to say? Don't come here?
Well, first of all, Your Honor,
it's the detective, not the DA, who's gone out of his way to take a simple assault accusation.
That is correct.
To the DA, not the DA seeking him to come there.
We don't know that.
Because how would we know that?
How would we know about this if we put him on the stand and ask him? I can't make that representation.
That's true. Does anything prevent your client from going to the magistrate and making an application for an arrest warrant for a simple assault when his only witness, as I understand, is your client and another person?
Exactly, Your Honor.
The detective marshal could not swear under oath to anything he's seen.
No, but he could certainly.
And that is a misdemeanor.
Certainly, exactly, and he could certainly have put them up. Brought them before the magistrate.
Can't they go themselves?
They can go themselves.
We tried.
They needed to have a police report, and they didn't have one police report.
They have one now.
Now they do, after Ms. Marshall wrote it down.
And how long have they had that?
That they've had since for a couple of weeks now.
And they haven't been to the magistrate yet, have they?
No, they haven't, Your Honor. They have not been at my
Nobody
instruction.
stopped them from going to the magistrate court, my point.
Your point is well taken, but it isn't relevant to my point.
Nor is your point relevant to the disqualification. What Detective Marshall is not even an investigator in the underlying case that this is all about.
Well, Your Honor, it just goes to show that the Rosenbaums are being selectively treated, and we are
When I say you complain to the police department, the chief, because it's his the detective that chose to go to the DA, not the other way around.
Your Honor, if I'd had him up on the stand, there's every possibility that he would have testified that he knew that Mr. Wright wanted, or Mr. Wright had indicated to him to bring this to him. So we would have had...
First off, he would have to know it existed. I'm not sure the district attorney gets called every time somebody calls the police department and makes a complaint about a simple assault. I don't think that's happening.
Well, Your Honor...
Maybe Detective Marshall, because he works in the detective's office, recognizes this defendant's name and says, whoa, this is against people that are related to the victim in this case. Maybe I ought to call the DA's office and see what I need to do different in the case, so I don't mess something up.
I understand the point, Your Honor, and I disagree with it entirely, but I certainly understand the court's point of view, and I accept the court's point. With regards to Mr. Moss, Your Honor, Mr. Moss, had he testified, would also have testified that his name was on tracker as the investigator on the case. And we want to make sure that the investigator on the case is not the cousin or the nephew of a political opponent. That was...
Let me make sure I'm clear. This picture you attached to the exhibit A is from October 27, 2012. Your client did not run in that election, did you?
No, but that's we are just showing the relationship, Your Honor.
Well, that's his daughter. I'm pretty sure that's clear. And I'm not sure what the relationship is, except that Mr. Wright and Mr. Moss's sign here together being held by Chip Moss's daughter 3-4 years ago, 3.5 years ago.
The relationship that they are trying to deny now existed since 2012.
The assistant DA just said he stipulated that no Moss is Mr. Moss's brother.
Your Honor,
We're trying to deny that's not the relationship. It's the fact that they supported Mr. Moss in his last election. I'm not sure they're supporting him this one or not. I don't know.
well, had we had our witnesses...
change their mind about who they vote for.
Exactly, and had we had the witnesses up on the stand, we could have asked them. There's lots of things that I can't proffer because I don't know, but that I can ask to a witness that's allowed to testify and be cross-examined.
I think it's good since your client never qualified to run.
My client was arrested, Your Honor, and charged
I didn't know her qualifying to run.
There is no chance, just as the court is making broad statements about what could happen, what could happen, there is no chance that she could win an election charged with murder. And the court sees otherwise. I certainly respect the court's position.
My point is there's no legal impairment to her qualifying to run for election, no matter what she's charged with.
There's no legal impairment. There's no legal impairment, but there's absolutely no way that a person is going to get elected. So it would be, the law does not require a person to do the unnecessary.
Maybe you ought to look at the District of Columbia. I think the mayor got elected after he got convicted for felony cocaine possession.
That's not good, Your Honor.
I'm just saying.
That's not good.
That was conviction.
Yes, for felony conviction of cocaine, not for murdering a child. Those are two different things. Those are two drastically different things.
But I don't see that it rises to the level of disqualification.
I understand the court's position, and I'm just trying to make my record known. That's all. I ask you to please note what we have presented in rebuttal as well, and I hope you will leave those statements and take those as true, as well as you have the states. And we would ask you to grant our motion, and we would ask you to reconsider allowing the opportunity for these witnesses to testify in live.
All right, well, let's see. Cite your own cases, 187 Georgia Appeal 649, State v. Mitchell. In that particular case, the solicitor objected to his being disqualified, and the court basically made a finding that he did not have to be disqualified, although they did not reverse the case. And in that particular case, the solicitor prosecuted his political opponent who actually physically ran, qualified, paid the fee, and ran against him in an election. And then was subsequently charged, along with someone who acted as campaign manager, also was charged with some violation of the law. And the court said this solicitor would not even be disqualified, although the court did, and they're not saying they didn't set it aside. It was not. So that's an actual election where the defendant, That's not a appearance of an impropriety I will live. The person who wins the election now prosecutes people randomly. That would intimidate maybe somebody running the next time, I would think. Okay? But and they said no. That's your case, not mine.
That's, Your Honor, I would just note that that's dicta and that they did not reverse.
Correct. They said the judge has the right to replace the solicitor, regardless, whether he was disqualified or not.
But they didn't
But
make
they
it.
made the specific case. You want me to read what they said?
No, Your Honor, I know what it says. I read it and know what it says.
This case would not appear to require the disqualification of the solicitor. That's what it said. 10 seconds, Williams versus State, another one you cited, right next door in Clayton County, 258 Georgia 305, 1988 case, and this one they actually found there was a disqualification, should have been. District Attorney Bob Keller, before he was DA in Clayton County, was a